Okay, there was an interesting ruling today. United States District Court Judge Anna Brown has struck down the U.S. no-fly list, saying it violates one's fundamental rights under the United States Constitution. In a 65-page opinion, the judge stated that international travel is not a mere convenience or luxury in this modern world. Indeed, for many, international travel is a necessary aspect of liberties sacred to members of a free society. She went on to rule that the no-fly list constitutes a significant deprivation of their liberty interests in international travel. Essentially, by using the wordings that she did with the significant deprivation of liberty interests and that it's not a mere convenience or luxury and that it's a necessary aspect of liberties, she's basically defining a fundamental right under the United States Constitution. Since it is being defined as a fundamental right, the people on the list should be entitled to a hearing under the Constitution to determine whether the government has a compelling interest. Actually, they should be entitled to notice any hearing. They didn't get any of this because basically these plaintiffs just arrived at the airport and found out they were on this no-fly list. The federal government's decision to ban them from travel must also be narrowly tailored to achieve a compelling interest. In this particular case, 13 plaintiffs, like I said, they only learned about the no-fly list when they were at the airport, were not permitted to board the flight. Since the plaintiffs were placed on the list with no opportunity for a hearing, the ruling by Judge Brown automatically makes the no-fly list a violation of the Fifth Amendment due process clause since they had no chance to respond. This does not mean they can't be placed on a no-fly list. All this legal mumbo-jumbo really means is that the federal government must provide for a notice and a hearing before placing someone on the list, and the government will have the burden to prove that they have a compelling interest that is narrowly tailored to achieve their interest of protecting their public. Protecting the public, I should say, since we are part of the public, so it's not their public. But whatever it is, without a notice and a hearing, it is in violation of one's due process under the Fifth Amendment to the United States Constitution, since the judge ruled that international travel is a fundamental right in this particular ruling.